So in this video, we're going to be talking about what happens if you're charged with drink driving, what to expect at the police station, and then what happens when the case goes to court, and also whether you need a solicitor. We'll also be talking about options that might be open to you in certain circumstances, because remember that you don't always have to enter a guilty plea to a drink driving offence, and you may not be guilty even if you provided a breath reading over the legal limit. We're not in this video going to be talking about blood samples or urine samples. There's a lot more to talk about in those kind of cases, so we'll cover that in a different video. As always, if you've got any questions about a case, if you're in a situation where you or somebody you know has been charged with a drink driving offence, then feel free to get in touch, because any of our initial advice is completely free of charge. We're happy to discuss the case over the phone with you. So if you're in a situation then where you've been caught drink driving, then the chances are you were either pulled over by the police and asked to carry out a breath test at the roadside, or you're in a situation where you've been involved in a car accident, the police have arrived on scene and arrested you on suspicion of drink driving. There may or may not have been a breath test. You're then taken to the police station. Sometimes you're taken to the hospital, depending on whether you have any injuries or suspected injuries. Again, that's not something we're going to be talking about in this video, because it would go on for too long. We can talk for days about hospital cases and hospital procedures, so we're going to be talking about police station procedures in this video. So you're arrested, either you failed a roadside breath test or the police have skipped that part, which they can do in certain circumstances, and you're taken into police custody. Now, what happens when you arrive at the police station? Well, first of all, you're normally checked in at the custody desk with the custody sergeant. The officers who arrested you would normally be with you at that stage. They're going to be stood next to you at the custody desk and possibly relaying some information to the custody sergeant as to why it is that you've been arrested in the first place. The custody sergeant will then ask you some questions. He'll carry out a short risk assessment, because the sergeant is in charge of your care, your safety, your well-being in police custody, and he needs to know that you're safe and well enough to be detained. There might be some mental health questions that he asks you. Have you ever had any thoughts of suicide or self-harm? The questions can be quite invasive and quite blunt, but you're normally required to answer them. He'll carry out that short risk assessment. He'll ask you whether you take any medication, and once that process is complete, they're probably going to want to breath test you fairly quickly. Now, drink driving offences are time sensitive, and the police realise this. They're going to want to get you on the breath machine as quickly as possible for obvious reasons. The police, they're going to want the highest breath reading, and the easiest way to get the highest breath reading is to fast track it. It's to get you in that room on that machine as fast as possible and get you blowing into that device, because alcohol levels are going to drop and reduce over time as you eliminate and you burn off the alcohol that's being consumed. So you're taken into what is normally quite a small, quite a confined, sometimes a claustrophobic breath test room. You're staring at what is quite an outdated evidential device, and these evidential devices, these breath machines, were first type approved back in the 1980s and actually haven't been updated or modernised or even improved since that point. And there are 2 or 3 police officers that are with you at that stage as well. You're not normally able to speak to a solicitor before the breath test, and you're not normally able to make a phone call before the breath test as well. And that's mainly because they don't want to delay the procedure and allow for the alcohol levels to come down, to drop. Now, before you blow into the machine, have a think about whether you recall the police officer going through any paperwork or asking you any questions. Drink driving cases are very different to other offences the police will prosecute, because really what you're being asked to do at the police station is self-incriminate. Now, if you were arrested on suspicion of a completely separate offence, take an assault for example, in a situation like that, the police will go away and they might gather evidence. They'll speak to witnesses, they might check CCTV. If there's a weapon that's been used, they'll try and find the weapon. There might be DNA or forensic evidence or mobile phone footage or mobile phone data, which the police rely on. So they'll go away, they'll gather the evidence, and they'll build a case against a person. But there's not really any of that in a drink driving case, because all the police are relying on you doing is incriminating yourself in police custody, providing a sample of breath, which the police will then use in evidence against you, assuming you're over the legal limit. And so the law says we have to be extra careful in drink driving cases. There has to be additional safeguards, statutory safeguards in place when a person is asked to incriminate themselves. And that's in the form of what we call an M.J. document. Now, I won't go into too much detail during this video about M.J. M.J. DDA documents, because I covered that in a recent video, and I will pop a link in the description. I'll stick a link up there to the video that I recorded on the M.J. DDA procedure. But in summary, it normally involves the police officer completing what is usually a 20-25 page booklet with you in the breath test room, about 30 questions the officer should ask you, as well as some general legal requirements and warnings. Now have a think back as to whether you remember the police going through that document in that breath test room, asking you various questions, ticking boxes, writing down your responses to those questions as he goes through them. And there's also various requirements that they have to give you as well. So did the police formally and legally require you to provide a sample of breath, or did he just tell you that you had to give a sample of breath? Did they make it sound optional? What did they say would happen if you didn't provide a sample? They'll sometimes try and make it sound a lot worse if you refuse to give a sample of breath in police custody. Were there any options of blood or urine? In certain circumstances, there should be. Was the mouthpiece replaced on the device? Do you remember the machine making any funny noises? Did you clock the sticker on the machine that might have shown the last calibration date or service date? Would the officer have made any passing comments about the machine not working properly recently? So of course all of this matters in a drink driving case, because that breath reading, at least for the prosecution, is some of the most important evidence, if not the most important evidence, that they can gather against you in a drink driving case. If there's any issues with the reliability of that reading, if they can't use it because the procedure was not carried out in the right way at the police station, then of course you're not going to be convicted for the offence of drink driving. So the most important part of your stay in police custody is really what goes on in that breath test room. Now also, do you remember the police filming the procedure? Because a lot of police officers now wear body cameras, primarily for their own safety, but that can double up as evidence in a drink driving case, because a police officer very rarely will accept that a mistake has been made in a witness statement. And it's amazing sometimes the difference between what you read in a witness statement, a police officer saying that he went through the procedures properly, that he asked all the right questions, that he went through the M.J. DDA document and that took 40 minutes, it took 50 minutes, it took an hour. But of course you then get CCTV through, which the police may not have realised you were ever going to access. Maybe they thought you were just going to plead guilty. And the CCTV is very different. It tells a very different story to what a police officer has put in a witness statement. Maybe the officer just copies and pastes these witness statements from one case to another to save on time, to save on admin. So always try and get the body-worn video or CCTV from that breath test room. Now remember, that footage can be copied over quite quickly. Sometimes it's important to make these requests even before first court dates for any CCTV or body-worn video as well. Now, once you've provided a sample of breath, and assuming you provided those samples, they're going to take you out of the breath test room, where they might process you for mug shots and fingerprints and DNA, or they might just stick you in a cell and allow you to sober up. If you didn't provide a sample in the breath test room, they might be considering a charge of failed to provide. Again, this isn't something we're going to talk about in this video. We have filmed other videos on failed to provide offences, and I will link those in the description of this video. Now, you may then spend some time in a police cell. It could be an hour, it could be 8 hours, depending on the alcohol level. Now, lots of people will say to me, well, before I left the police station, I was expecting to give a statement. The police didn't even take a statement from me. Generally speaking, if you're pulled over for a drink driving offence, the police won't interview you, because think about it, there's no reason to interview you. As far as the police are concerned, they've got all the evidence they need to prove their case. They stopped you, so they saw you driving the vehicle, so they can tick that box. They carried out the procedure with you, and they watched you give a breath reading that was over the legal limit. They can tick that box. So the police will say, we've got all the evidence we need to prove this case in court. Remember, the police will always try and make it sound as though their case against you is strong. They've got all this fantastic evidence. They'll sometimes say they've got independent witnesses. But it's never as simple or as straightforward as that. And often prosecution cases aren't as strong as they make out, or as strong as you might expect. Because remember, it's not necessarily the act of driving that makes you guilty. It's not necessarily the act of giving a sample of breath that puts you over the limit that makes you guilty. It's those little bits in between, those little intricacies between the roadside and the police station, the checking in procedure, what actually went on in that breath test room, whether they went through the process and the paperwork with you. It's that which, for me as a defence solicitor and challenging these cases day to day, it's that makes the biggest difference in a case like this. You might be watching this video and thinking, well, I was over the legal limit, I was stopped by the police, I might have pleaded guilty at the police station, which by the way you actually can't do. do, even if you indicated a guilty plea at the police station, and people think they're bang to rights. But that's simply not true. The majority of drink driving cases that we go on to win, our clients are pulled over. They're over the legal limit, often well over the legal limit. But if the police don't do their job properly, if they don't do their part and stick to their own rules, then they shouldn't be entitled to achieve a conviction in the courtroom. They shouldn't be allowed to use evidence which has been gathered as part of that investigation, like a breath reading, for example, if they haven't given you all your rights, all your options, all the correct legal information that they should have given you in police custody. And day to day, it's how a lot of these cases will fail. But before you leave the police station, they may not want to interview you. If they do, that's fine. And always make sure that you ask for a solicitor if you're going to be interviewed. It may be, of course, that if you're watching this video now, you've already left the police station, the interview has already happened. Don't worry too much about what you said in the interview. Now, I know that for most people, certainly the people that I speak to, at the point at which they're interviewed, they've probably spent a lot of time in police custody and they just want to get out of there. Now, sometimes honesty is the best policy in a police interview. Sometimes it's better to say nothing in a police interview and just go no comment all the way through. But again, don't overthink the situation or the case, and don't think you've buried yourself if you have said certain things in that interview. Now, normally, if you're over the legal limit, the police are going to want to give you a court date before you leave the police station. If you've left the police station without a court date, that could actually be quite interesting. That can be a positive sign. It may suggest that there's something the police need evidence-wise, which they haven't got. So if you're in that situation, please get in touch and we can try and figure out what that might be or the reason for that. If you've been given a court date, on the other hand, don't panic and think that means the police have all the evidence. It's just that it's normal to be given a court date once you leave the police station, and that court date can be a lot sooner than you expect. Now, again, the police may never admit to this, but I'm certain that one reason why they give court dates so soon is because they really want people to plead guilty. You know, if I was a police officer, I'd probably want people to plead guilty because that streamlines the process, it cuts cost for the prosecution, it means that your case is resolved on that court date. It goes towards conviction rates and conviction quotas for the year. The police and the prosecution may never accept that, but I'm certain that plays a part in why people are given court dates so soon. It puts the pressure on you. It's more difficult to try and locate and find legal representation in those circumstances, and it's probably more likely that you enter a guilty plea for that reason. Now, always try and find a solicitor to come to court with you. And you may know from reading our blogs, our case studies, maybe watching our other videos on our website, that of course there's different types of solicitors that can attend court to represent clients. You could even employ a barrister through direct access to come to court with you on that court date. What I would say is that because of how technical drink driving cases potentially can be, if we're challenging the reliability of a result, if we're looking at those little details during the procedure, talking about MGDDA procedures, the way you're processed in police custody, maybe issues surrounding mental health. We regularly defend cases if clients have autism, ADHD, mental health conditions, depression, anxiety, panic attacks. These can all amount to certain defences. So make sure that whenever you instruct a solicitor, the solicitor is well versed in dealing with this area of law, has a proven track record in defending cases like these, and ultimately knows what to say and how to handle a case on that court date. And make sure you get support, regular updates, make sure you get a mobile number for the solicitor that's acting for you. There's nothing worse than employing a solicitor and you never hear from them again. You can't get in contact with them again. Certainly from our point of view, we always give clients our mobile numbers. Evenings, weekends, there's always ways that you can get in contact with us. So try and arrange legal representation ready for the court date. Now, one more sort of secret, if you like, is that you can get some of the evidence before the first court date. Back in the day, you had to wait until the first court hearing to get all the initial evidence from the prosecution. And that was tricky because it meant that you couldn't really prepare in advance of the court hearing. You didn't really know what the police or the prosecution had. It was really dependent on what the client remembered, and sometimes they can't remember much because of what happened at the police station, maybe because of alcohol had been consumed. So you had to wait until the court date, you had a 5-minute conference before the case was called on, and you had to make the best of a bad situation. But things have changed more recently with what's called Common Platform. And Common Platform is a portal that the prosecution now use to upload evidence. And that evidence is normally available about 2 weeks before the first court date. So one of the first steps, particularly if your court date is soon, is to try and get our hands on as much of that evidence as we can. We sit down together, we go through things, and we can make more informed, more calculated decisions based on the evidence provided by the prosecution. Now, you might think, well, my only option is to enter a guilty plea. A solicitor goes through the evidence, picks apart the prosecution's case and identifies a number of errors or mistakes or discrepancies, inconsistencies with what the prosecution have put together. And of course, they're all good reasons to plead not guilty in a drink driving case if we think the CPS haven't got the evidence that they need. Likewise, of course, there are times where a person might be intent on pleading not guilty, all the evidence comes in and everything looks good for the prosecution. Now, of course, that doesn't stop you from pleading not guilty because that might be for other reasons, but the point is you get the evidence first and then you can make decisions based on the information available. And that's always one advantage, I suppose, in being a defendant in a situation like this, is that at least you get to see what they've got first before you make your first move. So we'll try and get as much of that evidence together before the court date and then spend some time going through it. Now, what then happens on the first court date? Now, no doubt if you've got a court date approaching, naturally you're going to be worried, you're going to be anxious, you don't know what to expect. A few things to know first of all. If it is a plea hearing, so the first time you've been to court for this allegation, the police officers, the people that dealt with you at the police station, they're not required to be there and there's no reason why they would be there. Court isn't like what you see on television, and that's not to patronise anyone that's watching this video, but I know when I first started going to court many years ago, your only impression, your only idea of court is what you see on TV dramas, it's what you see on television, but actually it's a lot more relaxed than that. Magistrates, they're normally quite pleasant. Prosecutors, it's just a job, it's nothing personal. So you go into court, sometimes it's quite jovial, the atmosphere in court, because the magistrates are there, they're doing a job, and they know that they have to try and be fair with people that are in court. They of course appreciate that for anyone that's in court, it's going to be a worrying time. But normally we get to court early on, we sit down in one of the quiet conference rooms and we spend some time going through the paperwork that's available at that stage, maybe the evidence that we got beforehand, then maybe some more documentation and evidence available on the day. And when we're ready, then we go into court. Now, the difference, of course, between having a solicitor and not having a solicitor is that if you've got a solicitor, then generally you say very little in court, other than just confirm your full name, address, date of birth. The charge is read to you, it's put to you by the legal advisor. This is the person that advises the magistrates on points of law. They sit in front of the magistrates and you'll spot them straight away in the courtroom because they're sat facing the court in front of the magistrates. The legal advisor will put the charge to you and you would then answer with guilty or not guilty. Now, in most drink driving cases, if you plead guilty at that point, unless it's extremely serious and the magistrates are considering prison or community service, and therefore they need some input from probation, they're going to sentence you there and then. They may have to leave the courtroom for 5-10 minutes to agree on what the most appropriate sentence will be, but for most drink driving cases, of course, it's going to be the mandatory driving disqualification and probably a fine, financial penalty or a community penalty, and the case ends at that stage. The disqualification is immediate. You can't drive home from court. It takes immediate effect. Driving whilst disqualified, I should add, is a very serious offence, and depending on when the ban was imposed, it is an offence that can carry a custodial sentence. If you enter a not guilty plea, and I should say that I generally lean more towards not guilty pleas for the clients that I act for, because of course that's the only way a conviction can be avoided is by pleading not guilty, going on to challenge and defend the allegation. There may be a little bit more paperwork to fill out, which of course the solicitor will handle. There may be more of a discussion or a conversation in open court about reasons why we're pleading not guilty. They'll timetable the case, they'll set further directions, and the case is then adjourned off, normally 3 to 6 months for a trial. Doesn't mean to say it'll reach that point, and there's a lot that can go wrong for the CPS between a first court date and a trial date, and you can carry on driving normally between that first court date and second court date. And that is one benefit in pleading not guilty, is that you do continue to drive in the interim. Now, one common question that people ask me is, well, if I plead not guilty and I'm then found guilty, say at a later stage, is the ban not longer? Will the court throw the book at me, punish me for pleading not guilty when, say, they knew all along that I was guilty? Is sometimes the question that people ask me. Now, there's two parts to the sentence imposed in a drink driving offence: the punitive part of the sentence and the ancillary order. Believe it or not, the main sentence, the primary sentence in a drink driving case is the fine, the community service, or the custodial sentence. Now, of course, custody prison is very rarely imposed in drink driving cases. It's normally a financial penalty, 70, 80% of the time, and possibly a community penalty, 30%, 20% of the time, if it's more serious. Now, any credit for an early guilty plea only applies to the punitive part of the sentence. So you might get a short reduction on the number of hours of unpaid work, you might get a small saving on the financial penalty by pleading guilty early on. In real terms, on a fine, it might save you £100 by pleading guilty on the first court date. The driving disqualification, however, is not reduced because that's the ancillary order, and the ancillary order is not affected by the timing of a guilty plea. So even if you plead guilty at the first available opportunity, on the first court date, you would expect and you would hope that the magistrate would reduce the disqualification to thank you for pleading guilty. Unfortunately, they can't do that. And that's why, in my view, that in most drink driving cases at least, there's very little benefit in pleading guilty because there's very little credit on the guilty plea. The length of ban stays the same. You're doing the prosecution's job for them. And of course, you've not seen all of the evidence available because it's not going to be available on that first court date. It follows and it arrives at later stages once you enter a not guilty plea. But every drink driving case is different. Sometimes it is appropriate to enter a guilty plea, really hammer the mitigation and try and get the absolute minimum. You may just be more comfortable with that approach. But certainly in the vast majority of cases that I deal with and the clients that I represent, we plead not guilty because we want to try and keep the options open and we want to avoid convictions if we can. So I hope I've answered some questions about what to expect if you are charged with drink driving. Again, it's impossible in a single video to talk about what will happen in every drink driving case because every case is different and every case is handled in a slightly different way. If, of course, you have got any questions about the situation that you find yourself in, then please get in touch. All our initial advice is completely free of charge. You'll find our contact details on our website and, of course, we'll be pleased to discuss your case with you.